What is a breach of contract? Coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. I'm Jordan Farkas. I'm a retired attorney. I practiced for many years as an expert in small claims court litigation. I've written several books on court procedure, including on the small claims court, including the Ontario Small Claims Court Handbook. And I'm very grateful to be back with another video. It's been a while. Season's greetings to everybody. It's December 2025 as I record this. And I should say, taken an hiatus, but my intention is to get back to doing these videos in response to popular demand. I was very gratified to see a lot of new subscribers, despite the fact that I hadn't updated the videos in a while, and I apologize for that. And I'm grateful to those of you who have subscribed. And to pay it forward, so to speak, I want to really try, maybe make it a New Year's resolution, if you will, to really try to upload more videos more consistently and also do them in response to the feedback that I'm getting. And that's the reason for today's video, which is going to talk about the idea of breach of contract and what that means. What is a breach of contract? That's something that's coming up a lot in the comment section of my videos. And therefore, I thought it would be very prudent to talk about that because it is a term that kind of gets thrown around. Breach of contract, he breached the contract, she breached the contract. But what does it actually mean when we're talking about breach of contract? I was doing a series, by the way, if you've been a subscriber and following along, on various states across the United States. So I am taking a pause in that series. If you do want to see a video for a specific state or province or whatever area you may be in, remember that none of this is specific legal advice for your specific or particular case. But if you wanted sort of some general ideas about small claims court procedure and tips on winning in small claims courts in your jurisdiction, feel free to leave that in the comment section below, and I'll do my best to prioritize those who leave comments for specific jurisdictions that they want to have videos on. As well, if there's a specific topic that you'd like a video on, again, without it being specific legal advice, and I keep repeating that because some of the comments have been asking for specific advice, which I unfortunately cannot give you, but I can give general guidelines. So if there's something that's happened in your case and you want to leave that in the comments, I may just use that as the subject of a future video, and therefore you can learn from that. One other thing I wanted to mention is that as of the recording of this video, I'm considering doing, I don't know, some sort of Zoom call or group where people can ask general questions that I would answer to live. So if there is something that you are interested in having, then again, leave that in the comment section below. As I continue to get that feedback, that will definitely help me to tailor this channel for your specific needs. And that's what it's about. It's about helping you win in small claims court. And the way to help you do that is to get that feedback from you and to subscribe. And don't forget to hit the notification bell so that you don't miss a future video, maybe on a topic that's very important to you. Okay, so without further ado, what is breach of contract? And this is in context of small claims court. Of course, breach of contract is a legal term that applies across the board when you're talking about legality and lawsuits. But obviously our focus is small claims court, but I will talk more generally about the idea of what is a breach of contract. And those who have subscribed or have seen previous videos will know that I've got my trusty old school whiteboard. The only difference is that because of the passage of time, I couldn't locate my last whiteboard, which is a bit smaller. So you see it's a bit awkward here. This is a bigger whiteboard. I do intend on getting a different whiteboard. I don't know if it will be for the next video, but hopefully for in the very near future, so I can go back to a bit of smaller whiteboard so that I'm not holding it up awkwardly. And again, as I've mentioned before, you know, when I do get better and more proficient in actual video recording and digitalizing things and being a little less of a dinosaur, hopefully I can find a way to do this on the screen itself. But right now I'm very old school. You know, we lawyers are known, even though I'm retired as a lawyer, we lawyers are known for somewhat being dinosaurs. Not all lawyers, okay? I'm generalizing, but a lot of us, and I'm certainly one of those. I guess not the biggest dinosaur because I'm doing YouTube videos. A lot of lawyers that wouldn't even know how to use YouTube or record a video, but I'm not the most tech savvy, so forgive me. This is about substance over the actual technological or my skills as a video recorder. So breach of contract, what we have here is I've kind of itemized this into 4 different sections to really kind of drill down when we're talking about breach of contract. The first thing that one should consider is, was there a contract? Okay, so if we're going to start throwing around terminology like, oh, that guy breached his contract with me, well, let's first know if there actually was a contract. By the way, if it comes out based on this video, you feel that maybe in your case there wasn't an actual contract, that doesn't mean you're necessarily out of luck. A lot of jurisdictions have equity principles, EQUITY, equity, which means that you may be able to make a claim based on fairness, or maybe if a judge finds that there wasn't an actual contract per se, a judge may find other grounds for you to be able to sue. So don't give up, even if you don't feel like your case falls under the guise of breach of contract. Okay, this is because, again, a lot of people are mentioning that terminology, and frankly, that is probably the most common type of small claims court lawsuit. But don't give up hope if you're finding that your case may not fit specifically within these guides. Although, if you didn't really have a contract with somebody, the chances of being able to successfully sue somebody for not having a contract will probably be significantly diminished. With that said, so is there a contract? So the way to know if there was a contract or not is to know what are the components of a contract. Now, the specifics may vary from different location and jurisdiction, as I'm always saying, but there are some core principles that pretty much run the gamut for all contracts. I don't want to say worldwide, that sounds pretty broad scoping, but generally when you talk about contract, there are some basic elements that must be met in order for there to be a finding that there was a contract. And number one would be, maybe you've heard this before, was there offer and acceptance? In other words, did somebody offer you a service, let's say for example, and did you accept that service? Okay, so let's say for example, you have a beef with your landscaper, and no offense to landscapers watching this video. Maybe you're a landscaper who has a beef with a homeowner who didn't pay you. But let's say you hired a landscaper to do work on your garden. Okay, so did the landscaper make an offer you by saying, okay, I'm going to do work on your garden in exchange for you paying me $10,000? And you pay the landscaper $10,000 and the landscaper doesn't do what he was supposed to be doing. So that was a breach of contract, which again, I'll get more into when we go over all the definitions. But in terms of contract itself, the contract is right there. Okay, there was offer and acceptance. The landscaper offered to do work on your garden for $10,000 and you accepted. And bear in mind, that need not be necessarily a written contract. A lot of times it can be a verbal contract, okay? It doesn't have to be written. Of course, it's always better to get things in writing. It's much easier to prove your case when you have things in writing, and I've done videos on that. We'll continue to do more videos in the future. But even if you don't have anything in writing, don't despair. By the way, being in writing can take many forms. So you may not have an actual document that says contract at the top. It may be in the form of emails or text messages. But the main thing is that you should be able to prove that there was offer and acceptance between you and that landscaper. Okay, so that's the first element: was there offer and acceptance, whether verbal or oral or text. The next component of a legal contract is, was there consideration? Okay, what do I mean by consideration? Well, I kind of alluded to that before. Was there an exchange of goods? Okay, again, I'm kind of using these definitions broadly. If you go online or you go to ChatGPT or whatever AI tool, maybe you'll get a more precise definition. But basically, when we talk about consideration, in this case, for the landscaper, for example, we're talking about money exchanged. Okay, so the consideration here was the $10,000. The landscaper offered to do the work on your garden, you accepted, and the consideration here was the $10,000 fee for the landscaping services. So there has to be a fee. There has to be some sort of exchange. Again, it need not be monetary. It could be something that's for barter. Okay, you may agree to exchange one service for another. But then again, it may be a little bit more complicated when it comes to small claims court lawsuits, because then you have to try and put a value on that bartered service. So it's a lot easier when we're talking about dollars and cents, but there are different forms of consideration. I'm not going to get into all that in this video, maybe in a future video, but make sure that there is consideration as part of the elements of contract. The third element of a contract is legal capacity. Forgive me again, this is a very awkward, large whiteboard. The third element written there is capacity, meaning somebody has to be competent. Somebody has to understand the nature of what they're signing. Now, beware with this one, because a lot of times when somebody breaches a contract, they'll try to claim that they did not understand what they were signing. And, I can speak from my experience as an attorney in Ontario. When I was doing small claims court over there, it was very difficult to prove that you didn't know what you were signing, okay? Because generally courts want to be able to uphold contracts. They don't want people to try and wiggle out of them by saying, oh, I didn't understand what I was signing. So it's not impossible that somebody could, raise a defense based on saying that I didn't know what I was signing. But in general, that's a hard defense to raise. Okay, that said, if it's somebody could prove, or let's say a relative comes in and shows evidence that a person had dementia or clearly did not understand what was being exchanged or what was being contracted to, then that will be a challenge for somebody who wants to uphold that contract. So generally, mental capacity is something that is very important to demonstrate for the purposes of establishing that there was a contract. And again, the fallback is that there is capacity between two, regular consenting adults, if you will, but always bear in mind that you do want to make sure that you're dealing with somebody who, understands what they're signing. And finally, the last component, all the way on the end over here, if you can see on the end of the whiteboard, this is so awkward this way, forgive me, is legality. Okay, so you always want to make sure that the contract that's being performed is for a lawful purpose. In this case, that is, in the case of our example of gardening, the person is providing a gardening service to your garden, landscaping, I think I said before, to try and be consistent. So that's a lawful purpose, and you're paying money for that service. But let's say for drugs or any sort of illegality, then trying to go to court to enforce a contract that's to do something illegal is, again, I don't want to make sweeping generalizations, but to the best of my knowledge, that's not something that's going to be enforceable. You cannot contract legally for something that's illegal. Okay, so those are the four components in general terms of a contract. So that's your starting point. So when you talk about breach of contract, you want to know, is there a contract? And is there offer and acceptance, consideration, capacity, and legality of the contract? Now, assuming you get over that hurdle, then the next question to ask yourself that I jotted down here, was there a breach? Okay, so what does a breach mean? What does breach of contract mean? Well, breach means that somebody didn't fulfill their end of the bargain. So in the landscaping example, if somebody agreed to do the landscaping work and didn't do it, that would be a breach of the contract because there was a contract and the person didn't do the work that they were paid to do. Of course, this is where a lot of the disputes get murky, and that's why they are disputes, because the landscaper may say, oh, I did the work. And the homeowner may say, oh, but you didn't perform it up to the standard that you were supposed to perform it. Or the landscaper may say, you sent me 10 text messages saying that you want more work than what was originally agreed to, and therefore I did $10,000 worth of work. But if you want me to continue, you got to give me another 10,000. So we can get back and forth into all sorts of ways in which that can the idea of breach could get muddled, and that's why there are disputes in small claims courts to begin with. But using a very basic example, if somebody agreed to do the work and then ran off with your money, then that, yes, is a breach of contract. You still always have to prove your case in court. Okay, so never assume that your case is proven until you've actually proved it. That was an obvious thing to say, but the reality is that a lot of times this can get murky. But that's the idea of breach. Did somebody not do what they were supposed to do under the terms of the contract? The next stage, once we establish that there's been a contract and that there's been a breach of contract, are there damages? Okay, so I get a lot of times I get questions from people. I found something in my food and I didn't realize it was there. Well, did you eat it? No. Okay, so what happened? Well, I got really scared. Okay, did you go to the doctor because you were scared? No, but I was really upset that they put that in my food. Let's say somebody found a fly in their food or whatever the case is. So in that case, again, I can't speak for every single small claims court across the world, but based on my experience, that would not be a case of evidencing damages, okay? Because short of any sort of psychological trauma that's really demonstrable, not just somebody saying they're angry or they got angry for 5 minutes, but some real trauma or something that somebody really suffered, that wouldn't be considered damages. In the landscaping case that we talked about, yes, that would be damages. If somebody agreed to landscape your garden and you paid the person the money, then that would be damages if you didn't get what you bargained for. But again, sometimes it can get murky because let's say you didn't actually pay the person money. So you entered into that contract and then the landscaper ran away and didn't do the work, but you also never paid the person to do the work. Now, it sounds simple. Well, then there's no damages, right? Because you didn't lose any money. Well, maybe you were waiting 6 months for the person to do the work, and in the meantime, your garden got flooded, and it caused you more damages, and now you have to fix up the work that would not have occurred had this person actually stood by the contract that they signed with you. So it's not always, nothing's clear cut. That's why we have small claims courts. It's not always so clear cut. But in the basic example, you always want to obviously make sure that if you're suing, you actually have damages. In this case being that you sent $10,000 and the person didn't do the landscaping work on your garden. I talked about this earlier. I kind of alluded to it. Sometimes you'll get counterclaims for damages. So the landscaper may say, Not only do you not have damages, I have damages because you should have paid me a lot more than the $10,000 that you already paid. So a lot of times the idea of damages also gets into dispute. And the last one on the list is, it's a bit beyond the scope of the idea of breach of contract, but it is related to the idea of damages, and that is, have you mitigated? Mitigate, mitigate. What does it mean to mitigate damages? Well, what that means is that you have to do your best. Let's say you're the one who suffered damages. You sent the $10,000 to the landscaper who ran off with your money. You have to try to lessen your damages to the extent possible. So, for example, let's say it's December 1st, 2025, and you sent the $10,000. The work was supposed to commence December 10th, 2025, and the landscaper didn't do the work. You can't just sit there for another year while your land gets worse and worse, and then you try and claim, 2 years later that now you're out $20,000 because the landscaper didn't do the work. No, if you know, and it has to be a reasonable period of time that passes before you know whether or not the landscaper is going to come back. You can show emails that you've sent to the landscaper to prove that you tried to get the landscaper to do the work and he was ignoring your emails, etc. Once it's clear to a reasonable person, that's oftentimes a standard test in courts, a reasonable person. If it's clear to a reasonable person the landscaper is not going to do the work, you can't just say, oh, I've got this guy where I want him, I'm going to claim all these damages from him. Certainly you're entitled to get your $10,000 back, but don't think that you can just let the land lie without, you could let your garden, lie untreated. And if it gets worse and worse over time and all sorts of things occur, oh, I'm going to get the first landscaper for that because it's all his fault that I never got the landscaping work to begin with. No, you've got to go and find another landscaper to, do the work that was supposed to have been done. Sure, it costs you another $10,000, but still, the court does expect you to mitigate. Of course, every case depends on its circumstances, and there are various laws. Some courts have what's more known as strict liability, which means that oftentimes if there's a contract and somebody failed to live up to their contract, you can claim from that person, and the courts are pretty strict about upholding that. But other courts are a little bit more liberal in a certain sense, that before they award you, liberal in the sense of they're stricter, more liberal towards the defendant, I would say. So I should be careful how I use the word liberal. But in this sense, what I mean is that a lot of courts want to make sure it's fair. So yes, this person caused you damages, but you should be doing what you can to not incur more damages. You can't just sit back and say, not only am I owed the 10, but I'm owed another 10 because my land got all ruined over the course of a year. No, why'd you let it sit for a year? You should have hired another landscaper. Again, it could also depend. Maybe you can say, I didn't have any more money to find another landscaper. I sent that first landscaper my last $10,000, and therefore I didn't have any choice. So all the circumstances will depend, but the bottom line for you to understand, for your particular case, is to know that you always have an obligation to lessen your damages to a reasonable extent, okay? You don't want to sit there and just rely on suing the person who screwed you over, pardon my language, on the contract just because you've got them where you want them. Another reason for that, by the way, for your own sake to understand, is because anything can happen in court. So of course this channel is about helping you win in small claims court, and that's the goal. But at the same time, you never do know what's going to happen in court. So you don't want to, it sounds obvious, but you'd be surprised based on all the feedback I've gotten over the years from people in different small claims court situations. You don't want to be incurring costs for nothing. You want to try and lower your costs to the extent possible, also because you don't have any certainty when it comes to small claims court. That doesn't mean you shouldn't be suing for what's rightfully yours, but definitely you do have an obligation in most courts that I'm familiar with anyways, to lower your damages or to lessen or to keep your damages at a minimum, and that's known as mitigating, okay? So just to do a brief recap in the idea of what is a breach of contract, it starts with looking into whether or not there was a contract to begin with. The four main elements of whether or not there was a contract was there offer and acceptance, was there consideration, was there a capacity, and was the contract legal? Was it lawful? Number two is, was there a breach? What does it mean to be a breach? Did the person actually not perform what they were contractually supposed to perform for you? Number three was, are there damages? So did you actually suffer damages? Are you out of pocket? Did you pay this person money and not get the service that you paid the money for? And number four is, have you mitigated your damages? So have you done your best to try and lessen or to minimize the damages, the money that you've lost in this example of the landscaper, to the extent possible? So I hope that gives you a better understanding of what it means when people talk about the idea of breach of contract. So I hope you found this video helpful. As always, once again, if you wanted to leave a comment or have any feedback about this video, or would like me to discuss something that is of interest to you. The channel is still relatively in its infancy, although the subscribership continues to grow, and I'm very grateful for that. And as it does, it may get more challenging for me to respond to you personally. But at this moment in December 2025, there's a greater chance that I can respond to you in a quicker time. Again, to those who did comment since I did my last video, my apologies for the delay in responding if you are watching this video, but your comments are definitely appreciated, as is your subscribing. And don't forget to hit the notification bell so you don't miss a future video. It definitely encourages me to continue to produce videos just like this one. And you never know, I may just do a video on a topic of your choice. So don't be shy, leave that comment in the comment section below, or just general feedback. It definitely helps me as well. So until next time, I look forward to seeing you at the next video. Hey, thanks for watching. If you found that video helpful for winning your small claims court lawsuit, then you're not going to want to miss a future video. Hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your small claims court lawsuit.